India Legal presents Courts Roundup.
Hello, I am Tanya and you are watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. Before we begin, here are the headlines. Supreme Court stays contempt proceedings against Maharashtra Governor Bhagat Singh Koshiyari. Case relates to non-payment of rent for a government bungalow allocated to him when he was Chief Minister of Uttarakhand. Supreme Court allows acquisition of farmland for Chennai-Salem expressway project. Acquisition was opposed by farmers. Supreme Court orders a medical college in Telangana to pay compensation of rupees 10 lakh to a surgery course aspirant for illegally denying her admission to the college. Jammu Kashmir High Court says state facing onslaught from terrorists supported by Pakistan and ISI. Holds that by sending crucial photos accused has waged war against nation.
India Legal presents Courts Roundup.
The Supreme Court has stayed the contempt proceedings which was sought to be initiated against Maharashtra Governor Bhagat Singh Koshiyari by the Uttarakhand High Court, which had issued notice on the same. The contempt proceedings stem from the alleged failure of governor to follow an order of payment of market rent for a government bungalow which was allocated to him in his capacity as a chief minister.
The Supreme Court has stayed the contempt of court notice sent by Uttarakhand High Court to Maharashtra Governor Bhagat Singh Koshiyari for not paying the market rent for a government bungalow allotted to him when he was Chief Minister of the state. The bench of Justices Rohinton Nariman, K.M. Joseph and Krishna Murari issued notice to the state of Uttarakhand and tagged the petition with a pending plea challenging the basis at which the market rent rates were ascertained by the High Court. In his plea, Koshiyari has stated that since he is the sitting governor of Maharashtra, the bar under Article 361 of the Constitution cannot be ignored while issuing notice and plea seeking contempt action against him. Article 361 affords protection to the President of India and governors of states against legal action before courts. By way of background, in June 2020, the Uttarakhand High Court struck down a law brought by the state government to validate the preoccupation of state provided bungalows by former chief ministers and the illegal expenditure incurred on that account for over a 19-year period. At the time, the court had also directed that the former chief minister pay market rent for the term of their legal occupation over a 19-year period. A review petition filed against the verdict was dismissed by the High Court on August 7, 2019. In his SLP before the Supreme Court, Governor has contended that he was never a part of the process to determine market rent of the residential premises allotted to him. It is further contended that Koshiyari was in occupation of the residential premises under an order issued by a lawful authority under a rule which was not in dispute at the time of allotment. Further, he had vacated the same as soon as he was required by law to do so. Bureau Report.
A highway project in Tamil Nadu that will cut travel time between Chennai and Salem city cleared a big hurdle today as the Supreme Court allowed the acquisition of farmland opposed by the farmers along the planned route. The rupees 10,000 crore Chennai-Salem highway project had been held up by Madras High Court order last year, which cancelled land acquisition. That order was challenged by National Highways Authority before the Supreme Court, which has now overturned it.
The Supreme Court has upheld the notifications issued for acquiring land for the Chennai-Salem 8-lane Greenfield Expressway project, partly allowing the appeals of the Union of India and the National Highway Authorities of India, the top court reversed the Madras High Court judgment to the extent it quashed the land acquisition notifications. The court said that it has negativated the challenge against the notification issued under the National Highway Act. However, the top court has maintained the directions in paragraph 106 of the High Court judgment regarding the reversal of entries in the revenue records, which stood mutated following the acquisition notification. Fresh notification proceedings need to be issued with respect to the acquisition of those lands. A bench comprising Justices A.M. Khanvilkar, B.R. Gawai and Krishna Murari delivered the judgment in the appeals filed by the central government and the National Highway Authority of India or NHAI against the Madras High Court judgment which quashed the notification for acquisition of land for the highway project. On April 8, 2019, the Madras High Court quashed the acquisition proceedings for the 277-kilometer proposed highway passing through agricultural as well as reserve forest land. The prime issue in the case was whether prior environmental clearance was necessary before acquiring land for the highway project. A division bench of Justices T.S. Sivaganam and V. Bhavani Subbarayam of the High Court held that the prior environmental clearance under the Environmental Protection Act 1986 was necessary before acquiring land invoking the powers under the National Highway Act. The bench rejected the argument advanced by Centre, Tamil Nadu government and the National Highway Authority of India that environmental clearance was not needed at the time of securing the land for highway construction and that it was needed only at the time of actual laying of the road. The court termed this argument as putting the cart before the horse. The conclusion of the court was based on the fact that large tracts of agricultural lands and forest lands were proposed to be acquired for the project. The court said that the issue has to be approached applying the public trust doctrine as per which the state holds public land and resources at trust for benefit of people. The court put particular emphasis on the fact that the acquisition will impact large tracts of fertile farmlands. The court also noticed that the respondents had not disclosed the proposed plans for rehabilitation and resettlement of people who will get displaced. Bureau Report.
The Supreme Court has held that a petition filed by 94-year-old women to declare the 1975 imposition of emergency in the country as completely unconstitutional. It will be heard next week. The petition was listed for hearing on Monday before a bench of Justice Sanjay Kishan Kaul, Justice Dinesh Maheshwari and Justice Rishikesh Roy. The bench has listed the matter for December 14. In the petition, a compensation of Rs 25 crore has been demanded from those who played an active role in this unconstitutional act. Petitioner Veera Sareen claimed that she and her husband were victims of excesses of then government authorities and others during the emergency, which was implemented a few minutes before midnight on June 25, 1975. The emergency in the country ended in March 1977. Sareen said in the petition that her husband had a business of Delhi gold artifacts at that time but had to leave the country due to fear of being put in jail on the order of the government authorities. According to the petition, the petitioner's husband later died and had to face legal proceedings initiated against him during the emergency. They are still suffering the pain of emergency and the devastation caused during that time. Moreover, her family had to wander for 35 years for rights over their rights and property. The petitioner also mentions the December 2014 order of the Delhi High Court stating that the action taken against the husband of the petitioner was beyond any jurisdiction. The Supreme Court has ordered a medical college in Telangana to pay compensation of Rs 10 lakh to a MS surgery course aspirant for illegally denying her admission to the college. A division bench of Justices L. Nageshwara Rao and Hemant Gupta also ordered the college to grant admission to the candidate for the next academic year since the last date of submission for the current academic year had expired. The judgment came in an appeal filed by National Medical Commission against a judgment of Telangana High Court which had ordered the National Medical Commission, earlier called Medical Council of India, to create or sanction one seat to enable the respondent number 1 to get admission. The respondent number 1, Kaumudi, had applied for postgraduate course in surgery at the Kamineni Academy of Medical Sciences and Research Centre, Hyderabad, after securing a rank in National Eligibility Cum Entrance Test 2020. However, even though Kaumudi visited the college with her parent for admission, her admission process was not completed. Later, another candidate who was below her in the merit list was granted admission. She challenged the refusal to grant admission before the High Court. A division bench of the High Court directed Medical College to create an additional seat and accommodate Kaumudi. The National Medical Commission challenged this order, contending that additional seats cannot be created in this fashion. The Supreme Court agreed with the High Court that the college was indeed at fault for not having completed the admission formalities. The court, however, went on to add that additional seats cannot be created in the manner done by the High Court. We are joined by Advocate Shivam Sharma. Shivam, tell us about today's court proceedings in this matter.
Yes, in this case, the student version of event was that MS Komodi had visited the college with her father on July 29 and 30, but her admission process was not completed. On the other hand, the college said in the court he did not visit the college on those days. However, the latter's version did not hold water, as the college's own affidavit in the state high court revealed that the student and her father had visited the college on July 29 and paid the university fees. Moreover, in this also said though the bench agreed with the clear conclusion that she was intentionally and illegally denied admission for 2020-21, it did not support the affidavit court's direction to create a seat for Ms. Komodi this year. And therefore, it has been repeatedly held by the High Court that direction cannot be issued for increasing annual intake capacity. Yes.
Thank you, Shivam, for joining with us. The central government has urged Delhi High Court to sine die adjourn proceedings in its appeal to restrain Vodafone Group from initiating second arbitration proceedings under the India-UK Bilateral Investment Protection Agreement or BIPA. No statement was, however, made on whether the Government of India would challenge the arbitral award against it in the proceedings initiated by Vodafone under the India-Netherlands BIPA. Vodafone would not proceed with the second arbitration under the India-UK BIPA unless the award under the India-Netherlands BIPA was set aside by competent authority. In view of Centre's plea to sine die adjourn the hearing in appeal, that added. The court adjourned hearing in the matter with the remark that it would pass an order in the appeal. In 2018, the centre had filed an appeal against the single judge's refusal to restrain Vodafone from initiating second arbitration proceedings under the India-UK BIPA when the proceedings under India-Netherlands BIPA were still pending. The arbitration proceedings were directed against the retrospective imposition of tax liability on Vodafone following its acquisition of stake in Hutch. Recently, in the first arbitration proceedings, the Permanent Court of Arbitration at The Hague ruled in favour of Vodafone and held that Telco was entitled to fair and equitable treatment under the India-Netherlands BIPA. The Delhi High Court has reserved order in the petition filed by BJP leader Manoj Tiwari challenging the order summoning him in the criminal defamation case by Delhi Deputy Chief Minister Manish Sisodia. A single judge bench of Justice Anu Malhotra said that the order will be pronounced on December 17. The High Court has requested the trial court to defer the hearing in the defamation case till then. Sisodia had filed a defamation complaint against Tiwari and other BJP leaders, including Vijayendra Gupta, for alleging that he indulged in corrupt practices in relation to construction of Delhi government school classrooms. Subsequently, summons were issued by a special MP MLA court to Tiwari, Gupta and others. Challenging the summons and subsequent proceedings, senior advocate Pinky Anand, appearing for Tiwari, argued that the entire case was based on legally inadmissible evidence. She assailed Sisodia's reliance on newspaper reports that quoted Tiwari making the allegedly defamatory statement. claiming that the same was mere hearsay and secondary evidence. Appearing for Sisodia, senior advocate Vikas Pahwa submitted that he was not the stage to test the admissibility of evidence. He added that value of Sisodia's evidence would be seen by court concerned at time of the trial, when witnesses, including editors of media houses, would be summoned before it. Appearing for the state, Standing Counsel for Delhi Government Rahul Mehra also opposed Tiwari's petition. He stated that there was nothing preventing the BJP leader from going to Delhi Police or Central Bureau of Investigation with the corruption claim against Sisodia. The Jammu and Kashmir High Court has made an important observation regarding terrorist activities in the state. It has said that Jammu and Kashmir is facing onslaught of terrorist activities from the neighbouring country, which is orchestrated by ISI of Pakistan. Case relates to a person who was caught sending photographs of vital military installations to ISI.
While observing that Union Territory of Jammu and Kashmir is facing onslaught of terrorist activities from the neighbouring country, which is orchestrated by the ISI of Pakistan, the Jammu and Kashmir High Court denied bail to a person named Pankaj Sharma, who allegedly hobnobbed with ISI of Pakistan and passed on photographs of vital installations and troop movement to them. The bench of Justice Sanjay Dhar further observed, providing a vital information photograph to the intelligence agency of an enemy country, to my mind, is nothing but waging war against the country. As per the prosecution's case, the petitioner Pankaj Sharma sent photographs of vital installations of Indian territory to ISI through Facebook Messenger, and in lieu thereof he received money, thereby posing danger to the security, integrity and sovereignty of the country. On the basis of this information, an FIR came to be registered and Sharma was taken into custody. The pictures were allegedly sent to two Facebook IDs who claimed that they were stationed at Sudan, which were later found to be fake. The money is stated to have been received by petitioner and his relatives and friends from Dubai, Maharashtra, etc. Thus, according to the respondents, offences under Section 121 IPC and Section 3 of the Enemy Agents Ordinances are made out against the petitioner. The senior counsel for the petitioner submitted before the court that mere taking of photographs of some installations and sending it to same persons stationed at Sudan would not amount to either hobnobbing with enemy agents or waging war against the government of India. On the other hand, the respondents argued that the petitioner knowingly indulged in activities which are prejudicial to the security of the state. Court also noted that there is a material on record to suggest that petitioner, his mother and his friend Ashwani Kumar were receiving money in their bank accounts in exchange of these photographs. The court further noted that co-accused in the case are yet to be arrested and interrogated. The investigating agency has submitted that after their arrest and interrogation, supplementary charge sheet will be produced before the court. Bureau Report.
The Karnataka High Court recently issued notice to the state government and directed it to place on record the immediate steps it proposes to take for protecting surviving bird species of the great Indian bustard in the state. A division bench of Chief Justice Abhay S. Oka and Justice S. Vishwajit Shetty gave the direction while hearing a petition filed by conversationalist Edward Santosh, Martin and others. The bench said the Wildlife Protection Act has been enacted to provide for protection of wildlife animals, birds and plants. The definition of animal includes birds and definition of wildlife includes animals which include birds. Thus, it is the obligation of the state to protect the wildlife. It added that under Article 48A of the Constitution, state will have to protect and improve and safeguard forest and wildlife. The government has to respond on December 21. The petition states the illegal actions of respondents undertaking civil works such as construction of watchtowers and anti-poaching camps within the area of habitat of the species of pushed the species to brink of extinction, which is a blatant violation of Part 3, Schedule 1 of the Wildlife Protection Act 1972. Police states that the bustard is an open country bird that avoids areas with dense and tall plants. In addition to this, anti-poaching camps and 5 watchtowers are being constructed in great haste. These buildings and tall trees will cause hindrance to the birds and cause them to fly away in search of favorable habitats. The Calcutta High Court has pulled up Indian Bank and imposed cost of rupees 25,000 for stalling the back wages payable to an employee for over 5 years and for using its dominant position to continuously harass the employee. A single judge bench of Justice Shekhar B. Saraf said that imposing cost was necessary to ensure that such unnecessary litigation is avoided and state authorities comply with the letter and spirit of law. It also deprecated bank officials' attitude of acting only once the matter is settled by constitutional courts, leading to umpteen litigations. The court therefore opined that imposing cost was necessary to reduce such actions leading to litigation. The judgment was rendered in a plea by one Sandipta Gangopadhyay, who had been denied back wages from service. This attitude of bank officials in pushing the monkey off their shoulders and only acting once the matter. Gangopadhyay was placed under deemed suspension in 2014 after police detained him based on corruption charges leveled by a customer. The court directed the bank and its authorities to pay the differential salary to Gangopadhyay within a period of 4 weeks for the period commencing from May 2 to 15 till his date of joining, along with interest at rate of 8%. In the event the bank fails to make the payment, the court provided for further penal interest at the rate of 4% per annum on the differential salary till the payment. The Allahabad High Court cancelled the conviction of Javed Siddiqui, who is accused of arson and rioting in Dalit township of Jaunpur, under the National Security Act as illegal and directed his immediate release. Petitioner Javed Siddiqui filed this habeas corpus writ petition against the detention order passed on July 10, 2020 under Section 3(2) of the National Security Act and requested to issue direction for producing the corpus in the court and also for setting aside the impugned detention order. The facts of the case are: the petitioner, along with 56 known and 25 other unknown persons, came to slum locality of district Jaunpur and committed rioting, arson, used casteist words against the inhabitants of the slum locality, abused them and caused injuries by using lathi and danda, due to which many of the persons sustained injuries. They are accused of setting fire to the Badheti slum with a crowd of 75 to 80 people, rioting, beating and spreading chaos in which many people were injured and animals were burnt to death. The court quashed the district magistrate's order of detention of petitioner in jail on July 10, 2020 on the ground that authorities did not present the petitioner's report against the detention before the advisory council for 3 weeks. A heavy police force was deployed after the incident. An FIR has been lodged at Sarai Khawaja police station. That's it for Courts Roundup today. Keep watching APN.
India Legal presents Courts Roundup.